Hi everyone, I'm Mark Mix, President of the National Right to Work Foundation, and I want to kick off today's video by asking you a question. Whose decision should it be to bring a union into a workplace? If you answered individual workers, you're correct, and the foundation has fought for decades to protect the rights of workers to vote in secure, anonymous elections to install unions they want or to similarly vote out unions that are corrupt, ineffective, or just don't serve the workers' interests. As intuitive as this answer should be to anyone who values individual liberty, union-label federal bureaucrats are increasingly pushing the idea that union officials should be able to foist union representation on workers without even giving them a chance to vote in secret on whether they even want a union. Enter Jennifer Abruzzo, whom President Biden appointed to the position of National Labor Relations Board General Counsel in 2021. Abruzzo, a former Communication Workers of America union lawyer, seems to think that the path to safeguarding union elections somehow begins with twisting labor law to let union officials cancel elections entirely. To discuss this today, I'm sitting down with Foundation veteran staff attorney Glenn Taubman, who over his 4 decades of experience at the Foundation has litigated countless cases at the National Labor Relations Board for men and women opposed to union affiliation. Hi, Glenn.
Hi, Mark. Thank you for having me.
Welcome back to the studio. It's good to have you here.
Thank you.
Well, look, Jennifer Abruzzo's desire to basically simplify elections or at least promote elections for workers and unionization, her desire is to actually end elections, frankly, and basically take the secret ballot election right out of this process. You want to elaborate a little bit on what she's up to right now?
So, secret ballot elections have always been the gold standard. Everyone from the Supreme Court on down has recognized that. It's obvious. You wouldn't want somebody looking over your shoulder when you go to vote in your election. But the unions and Jennifer Abruzzo are pushing this idea of card check, and they've been pushing this for a long time. And the idea is if an employee signs a card that indicates support for the union, that constitutes a vote. But how are these cards collected? It could be a union official coming to this person's home. It could be a union official or union officials browbeating people to sign. And unlike a secret ballot election where nobody knows how you voted, the union bosses know exactly how you voted because they have the card. And if you refuse to sign the card, they know that that's in effect a vote against the union.
Glenn, if I understand the NLRB precedents that historically go back to basically 1935 or 1937 when the Supreme Court upheld the National Labor Relations Act, is the notion that neither a union or an employer should know how a worker votes. We also know that many times workers will simply say they'll sign the card just to get them off their back. I mean, even the AFL-CIO notes this, that, while we do card checks, most of the time workers, you have to get a certain number to have any chance of being successful because sometimes workers will just sign it to get you off their front porch or get you out of their face.
Right. In fact, that is very common. Workers report that all the time, that they feel the pressure and they sign, which is why the AFL-CIO organizing manuals say, if we have to go to a secret ballot election, we really need to have about 70% of the cards to have any prayer of actually winning the secret ballot election. So they know that these cards are subject to all kinds of abuse, and that's why they're pushing this, because it's all about getting them in power and not having these pesky secret ballot elections. In fact, I think it was the Unite Here president some years ago who was quoted as saying, "We don't do elections."
Yeah, that's kind of the mantra of union officials today because they need government engagement in order to convince people to join unions. This is not a new theory. This is Jennifer Abruzzo going back and trying to wipe out what is basically, 80 years of labor law and go back to this standard that was thrown out in I think a Supreme Court case in 1969 called Gissel that basically said, you know what, secret ballot elections are the preferred and in fact should be the methodology for certifying unions. Abruzzo wants to take all of that, wipe it out, and go back to this Joyce Silk doctrine. Can you go into a little more detail there?
Sure. So I like to quote Ronald Reagan, who said, the closest thing to eternal life on earth is a government program. And the National Labor Relations Act is really nothing more than a government program for the benefit of union officials. So here's Jennifer Abruzzo, a former communications workers lawyer, coming in and saying, wow, there's a case from 1949. That's by my math, what is that, 73 years old. And she wants to revive this case, which says employers must accept card checks and can't demand a secret ballot election, even though the Supreme Court in 1969 in Gissel said, no, the card checks are the rarity, that they should not happen except for the most extreme circumstances. And in many cases, as I said before, the Supreme Court has said secret ballot elections are the gold standard of free choice. And so we here push that in every case we have to safeguard secret ballot elections and to make it easier, not more difficult for employees to exercise their free choice to get rid of a union if that's their choice.
Glenn, I think we were involved in a case at Volkswagen down in Chattanooga, Tennessee back in, I don't want to say years because that starts to date me and I frankly don't remember it that well, but we ended up helping the employees at the Volkswagen plant where the union, the United Auto Workers Union, the corrupt United Auto Workers Union, came to the management of that plant and said, hey, we've got a majority of the cards, let's just accept them and let's start bargaining and let's get everyone in the union and get going and get this plant running. We exposed it. We got these employees to sign what's called another petition saying they didn't want to be represented by the union. It ended up going to a secret ballot election, and guess what? The workers voted against the United Auto Workers, even though the United Auto Workers said that we had a majority of the workers. This is exactly the scenario that unfolds when the union can do whatever they want under these new Abruzzo rules that she's proposing and wants to implement. The union can do anything they want to get these cards signed. And if there's nobody questions the age of the cards or how they were gotten, you present them to the employer and the employer would have to accept them. And the only way they could object to this was to have a good faith doubt that there was any question. Right. And then the board gets to adjudicate whether or not this good faith doubt is meaningful enough to challenge these cards. Is that right?
Right. No, that is exactly right. And if you leave it up to the Jennifer Abruzzos of the world to decide what is a good faith doubt, they're always going to say that there is no good faith doubt. And if the employer has one unfair labor practice charge filed against it, then they're going to say, well, this is an employer that violates the law. This is a recidivist employer. So certainly they can't have a good faith doubt. So again, the whole process is going to be slanted and rigged to make secret ballot elections difficult, if not impossible, all on behalf of unions getting in power and staying in power.
And her agenda, frankly, when she put out her first memo, was targeting the work that you had done over these years and the foundation had done.
Right. She put out a memo repealing a lot of the orders that the prior General Counsel had put in place that were favorable to our positions and our clients' positions. So one of the first things she did is repealed about 10 advice memoranda that the prior General Counsel had put out. The hypocrisy of Jennifer Abruzzo and her team is just astounding because they want card checks if it will bring the union in. But if employees collect cards and they say, we don't want the union, and a majority of the employees turn that over to their employer, according to Jennifer Abruzzo, will be forbidden from withdrawing recognition of that union based upon the very same cards that she's demanding that the employer has to accept if it's to bring the union in. And we won a case called Johnson Controls that affirmed employees' ability to get out of a union by collecting these cards against union representation. And now she comes and says, no, those cards are invalid. But if cards are signed to bring the union in, then everybody must accept them. So the level of hypocrisy out of this administration and this board leadership is just staggering.
Well, Glenn, there's a lot here, but tell me about what other aggressive actions they might be taking that are going to limit employee rights. I know we have other examples of that.
Yes, we sure do. And one of the big ones, a current case we're involved in, is called Red Rocks out of Las Vegas. And in this case, the union officials went to an election, a secret ballot election, which they lost. And after they lost, rather than accept the outcome, they went to the National Labor Relations Board, to Jennifer Abruzzo, which ran into federal court seeking what's called a 10J injunction to overturn the election that was just held. And they got a federal judge to issue an injunction saying that the company must recognize and bargain with the union even though the employees had just voted against the union. And so this increasing use of what's called 10J injunctions to run to federal court, because they can't even win within their own bureaucratic system. So when they lose, they go and they shop around for a judge who they can convince to enter an injunction. And that's what happened in Red Rocks. And we're involved in that case to uphold, again, the sanctity of a secret ballot election, not a card check or an order from a judge that foists the union on the workers, even though the union lost the election.
Well, it's not new to us here at the foundation what they're up to, but for the folks watching, this is a very interesting time when it comes to labor law, and it's a very interesting time for union officials too, because only about 6.1% of the private sector workforce are in unions. And so if they're going to maintain their political power and their power over the workers of America, they've got to expand their ranks. And unfortunately for them, workers aren't voting for them, but the power of the federal government is now being used to empower union officials and force workers into unions. Nothing new here, but something that the foundation is going to defend against with all the strength that we have. And so with that said, Glenn, first of all, thanks for being here. Thanks to all of you for tuning in today. Be sure to subscribe to the Foundation's YouTube channel for more videos like these, and follow us on Facebook and Twitter to keep up with our actions for worker freedom. On our website, www.nrtw.org, you can get information on your rights as an employee and request free legal aid if you believe you've been subjected to compulsory unionism abuses. Our bi-monthly newsletter, Foundation Action, is also available on our website. As Glenn and I discussed, independent-minded workers today are facing down a lot more than just power-hungry union officials. They're also fighting government agencies filled with union partisans bent on undermining their rights. That's why we're especially grateful to the Foundation supporters who have faithfully backed our efforts over the years to not only help workers exercise and defend their rights in the courts and at the NLRB, but also to promote the right to work message across platforms like these. Once again, I'm Mark Mix, and thanks for tuning in.